Hearing the appeal AM Zimbabwe against Secretary of State for the Home Department.
Before we begin, Mr. Malik, there has been an anonymity order to date in this case, but what's the good reason in principle for an anonymity order?
Lady, of course, you have seen from the papers that the appellant is HIV positive.
Yes.
That is the only reason that I can think of justifying that order. His family, I'm told, is not aware of his condition. His family, I'm told, is not aware of his condition, and he wishes to preserve the confidentiality for that reason.
I see. Thank you. Mr. Ivanov, have you any comment?
We have no objection at all.
You've no objection. We do routinely object to anonymity orders unless they can be brought within the sort of category where they ought to be made. Obviously, in asylum cases where there will be a risk if anonymity is breached on return, but that's not this case. But can I just consult my colleagues?
I thought that his wife or partner herself had it. But nevertheless, there's a child.
Yeah.
Kane is now 13.
Yeah.
So
Yeah.
that might be a reason.
Okay. Thank you.
Good. I agree with this.
Looks as if we are content to make an anonymity order. I don't think there's any risk that anybody would inadvertently disclose the identity of the appellant, but just in case, I'm reminding everybody that there is an anonymity order. It's particularly important in this court, of course, because our proceedings are live streamed, and once there's been a slip, it's impossible to retrieve it. So, very well. Thank you, Mr. Malik.
I'm very grateful. So I appear for the appellant AM this morning with my learned friend, Mr. Balroop. My learned friends, Ms. Giovannetti, QC, and Mr. Dunlop, QC, appear for the respondent, the Secretary of State for the Home Department. My learned friends, Mr. Banner, QC, and Mr. Vanderman appear for the intervener.
And the fact that they were both of them judicial assistants in this court or its predecessor in no way predisposes us to agree with their arguments.
Well, ladies, my lords, this appeal concerns a person who is facing deportation to Zimbabwe. He came to this country 19 years ago as a child, and he is seeking to resist his deportation on the basis that it would be incompatible with Article 3 of the European Convention on Human Rights. That article, as the court knows, prohibits anyone from being subjected to inhuman or degrading treatment. The appellant is HIV positive. His condition is presently controlled by a particular drug, which is not available in Zimbabwe. If his condition is not controlled by an appropriate drug, he will be at risk of developing infections, cancers, and premature death. There is, however, no risk of imminent death. The lead domestic authority on the subject is the decision made in 2005 by the House of Lords in the case of N. That decision was subsequently endorsed by the Grand Chamber of the European Court of Human Rights. As read by the Court of Appeal in the case of GS India, that decision provides that a person may only succeed in a case of this sort if that person is on the deathbed. On that basis, the appellant conceded before the courts below that he was unable to succeed in his claim because his case was not a deathbed case. The Grand Chamber of the European Court of Human Rights, in the case of Papuashvili, has now adopted an approach that is different from the approach taken in the case of N and in the case of GS India. However, despite the decision in Papuashvili, all domestic courts and tribunals, apart from this court, are bound to follow N as read in GS India. 2 points of general public importance arise in this appeal. First, whether this court should depart from N as read in GS India and instead follow the approach taken in Papuashvili. Second, whether the Court of Appeal's reading of Papuashvili in this case is correct, and if not, what is the correct reading of Papuashvili?
Well, logically, the second one comes first, doesn't it?
Yes.
Because we can't possibly decide whether it's appropriate to modify N until we've decided exactly what Papuashvili decides.
That with respect, is correct. I accept that.
Do you propose to take the issues in that order?
Yes, I was proposing anyway to deal with the issues together, but of course I will deal with the first issue first. So in the light of the answers to these 2 points, the court will decide whether to remit this appeal to either the first-tier tribunal or the upper tribunal for reconsideration. I shall seek to persuade my ladies and my lords that it is appropriate for the court to depart from N as read in GS India and follow Papuashvili. The Secretary of State accepts that this is what this court should do. There is, however, a dispute between the parties as to how Papuashvili should be read. My submission will be that the Court of Appeal's reading of Papuashvili, which is supported by the Secretary of State, is wrong and inconsistent with the clear language used by the Grand Chamber. On the facts of this particular case, I shall seek to persuade my ladies and my lords that it would be appropriate in all the circumstances to remit this appeal for reconsideration and findings on the correct legal basis. So I propose to address the court first on the points of principle, and I will take the court to the key authorities on the subject and make brief submissions as to the effect of those authorities. I will then address the courts as to the facts of this case by reference to the decisions made below. So first, the points of principle. In N, the House of Lords considered and applied the decision in D. So it is appropriate for me to take the court to that decision first. That decision is in Authorities Volume 2, tab 15, MS page 1071. As the court would know, was a case where the applicant was in an advanced stage of AIDS. The court treated that as an exceptional case and found that the applicant's removal would breach Article 3. If I may respectfully take the court to page 437 of the report, this is MS page 1085. Just above paragraph 53, there is a heading under which the case law as to Article 3 is discussed. What is said at paragraph 53 is not controversial. It is well established that a person's removal to a third country can engage Article 3 if there is a risk that that person will face inhuman or degrading treatment in that country.
Well, that's the Searing principle.
Absolutely, yes.
This is the Commission's opinion, isn't it, Mr. Malik?
That is correct, yes. Paragraph 54 is the paragraph where it was said that one has to consider medical care or facilities, social or environmental circumstances in considering such a claim. Paragraph 53, a point was made that only that person can make a claim of this sort who is present in the United Kingdom. So a person who is not in the jurisdiction cannot seek entry on the basis that he is facing ill treatment in his home country. Paragraphs 58 and 59.
54 is important, isn't it? Because we're talking about the interpretation of the convention as an international treaty.
True, yes.
In accordance with the Vienna Convention.
Yes.
Why are we looking at the Commission and not the court?
Simply to just to provide the context of the case. But because the court's decision was considered in N, I'll take you to N where that case was considered. May I simply flag up what is said at paragraphs 58 to 69? Now, the court's decision was considered in N, and just to save the court's time, if I may take the court to N, because that summarizes the principles in D. N is behind tab 10 of the authorities volume. Authorities volume 1, it's MS page 842. The case concerned a woman from Uganda who was suffering from HIV. She was receiving effective treatment in the United Kingdom for her condition. That treatment was not available in Uganda. Applying D, it was held that her removal would not breach Article 3. If I may respectfully take the court to paragraph 24 of the judgment. This is at MS page 852. You'll see, my ladies and my lords, that in that paragraph, Lord Bingham referred to what was said. Lord Hope referred to what was said by...
Lord Bingham wasn't in the case.
No, Lord Hope referred to what was said in Lord Bingham in the case of Ulla. What is said in the first part of that quotation has now been subject of some further case law. But if you look at the middle of that paragraph, just between letters D and E, you'll see that it was said that convention is an international instrument, and the correct interpretation of which can authoritatively expounded only by the Supreme Court. And the last sentence says that the duty of the national courts is to keep pace with the Strasbourg jurisprudence as it evolves over time. No more, but certainly no less. There is then a comment by Lord Hope at paragraph 25 that the court's task is to analyze jurisprudence of the Strasbourg court, and having done so and identified its limits, to apply it to the facts of a particular case. It is for the Strasbourg court, not for us, says Lord Hope, to decide whether its case law is out of touch with the modern conditions and to determine what further extensions, if any, are needed to the rights guaranteed by the Convention. We must take its case law as we find it, not as we would like it to be. This is the approach that I respectfully invite the court to adopt, and I emphasize respectfully what is said in the final sentence of that particular paragraph. The court must take the decision in Paposh Willie as it finds it.
Yes, Lord Hope was making that remark in sorrow rather than the other way round, whereas you would say that we should not row back from whatever Paposhvili decided because we think it may be too generous or unrealistic or whatever.
Absolutely, and that is the submission that I propose to develop briefly in due course. The submission that I will make is that the Secretary of State is simply not happy with what is said in Paposh Willie, and for that reason is asking the court to gloss on what is said. But the court, in my submission, must not do that. If you then, my ladies and my lords, look at paragraph 35, this is MS page 858. You'll see that Lord Hope made a comment in that paragraph that it would have been helpful for the Strasbourg court in D to have done more to identify the criterion to be applied. The phrase exceptional circumstances, he said, does not provide that kind of guidance. That, with respect, was a valid comment, and the Strasbourg court has now provided that helpful guidance. Then look at paragraph 36. This is where Lord Hope identified why D's case was considered to be exceptional, and you'll see repeated references to the fact that D was terminally ill and had reached the final stages of his fatal illness. That was the fact that made his case exceptional. The point was repeated at the end of paragraph 50, just against letter G. This is MS page 862. The appeal was dismissed on the facts for the reasons given at paragraph 51. If you look at the last two lines on that page, page MS 862, you'll see that N's condition was stable, and so long as she continued to take the treatment, she would remain healthy. She was fit to travel, and it was open to her to obtain treatment on return to Uganda. And for that reason, it was said that the case was not exceptional. Then have the judgment of Milady Lady Hale starting from MS page 864. And Milady made a comment at paragraph 59 that the strengths of a claim does not depend upon the history, no matter how deserving or undeserving of our compassion, but upon the present situation and her immediate or very near future. And I respectfully invite the court to look at the facts of this case with this observation in mind. It may be that AM, the appellant, is seen as undeserving of any compassion in the light of his history in the United Kingdom, but that it is common ground is simply irrelevant.
That's another example of turning things round from
Yes.
what the context was in which the statement was made, isn't it?
Yes, but what is said in my respectful submission applies with equal cogency other way around. If you then go to paragraph 69,
But just on paragraph 59, do you say that the our house in N did look at the prospects of her receiving the treatment in Uganda?
yes, and it was said that she can obtain treatment she needs on return to Uganda, and there was evidence that treatment she needed was available in that country. She also had relatives there.
Is there just a difference between availability and whether there are prospects of her getting the treatment?
True. I think the point is dealt with at MS page 863. This is paragraph 51, just first few lines on that paragraph. So you'll see that Lord Hope was considering as to what would happen in Uganda. But the test Lady Hale identified in paragraph 69 of the judgment, you have that paragraph at MS page 868. The test is whether the applicant's illness has reached such a critical stage, i.e. he is dying, that it would be inhuman treatment to deprive him of the care which he is currently receiving and send him home to an early death, unless there is care available there to enable him to meet the fate with dignity. It's fair to point out that paragraph 70, Lady Hale said that apart from a case that meets that test, there may well be other exceptional cases with extreme facts where it would be inhuman to return someone to his or her country of origin. But as the court will see in due course, no case has succeeded since at the Strasbourg level. Paragraph 71, you see that Milady felt compelled to dismiss the appeal in those circumstances, much though she would like to be able to allow it. So this is what was said in N. This was endorsed by the Strasbourg court. Subsequently, the Strasbourg judgment is behind tab 18 of the Authorities, Volume 2. Now, may I respectfully take my ladies and my lords to paragraph 34 of the judgment. This is at MS page 1160. You'll see that an observation was made that since the judgment in D versus UK, the court has never found a proposed removal of an alien from a contracting state to give rise to a violation of Article 3 on the grounds of the applicant's ill health. The test was so high and, in my respectful submission, unrealistic. And when I will show, my ladies and my lords, subsequent case law, it would appear that even after N, no one succeeded in meeting that test. If you then go to page MS 1169, you will see a heading, the principles to be drawn from the case law. If you look at paragraph 41, just middle of that paragraph.
Paragraph
Paragraph 42.
42.
Yes. Just middle of that paragraph, there is a sentence the fact that the applicant's circumstances, including his life expectancy, would be significantly reduced if he were to be removed from the contracting state, is not sufficient in itself to give rise to a breach of Article 3. Only a case with exceptional circumstances would succeed, and the case would be exceptional if a person is critically ill and appeared to be close to death. You'll see that paragraph 43, the court made the point that my Lady Hale made at paragraph 70 of the judgment in N, that apart from this test, there may well be other exceptional cases with extreme facts where it would breach Article 3 to remove a person. What is said at paragraph 44 was quite controversial. You'll see that a point was made that it was inherent in the convention that a fair balance is to be achieved between the demands of general interest and the requirements of the protection of a person's fundamental rights.
I think you're right. I think one of the points made by the dissenters was that, with all due respect, a fair balance of that sort doesn't come into Article 3.
Absolutely. You'll then see that the court applied the principles to the facts of the case. Paragraph 48, you'll see a reference to the information that appropriate medication was available in Uganda and that the applicant had family members in that country. Paragraph 50 is the overall conclusion on the next page. The court accepted that the quality of the applicant's life and her life expectancy would be affected, but that was not sufficient. The dissenting opinion starts from the same page, and you'll see that the dissenting judges gave 4 particular reasons for disagreeing with the majority. The first of those reasons is at paragraph 015. So the dissenting judges said that the dissenting judges could not agree with the majority when they made the comment that is quoted at paragraph 015. The second reason appears on the next page, MS 1173, paragraph 016. So before you look at that, if I may ask you to look at the first sentence at page MS 1173. The point that is made by the dissenting judges was that the principle applies equally where a person is at risk from the state or from illness. The second point is made at paragraph 016. And the dissenting judges took the view that the majority formed its view on the basis of an incomplete statement in the convention. Paragraph 017 is the paragraph where the dissenting judges made the point that Lord Wilson just identified. And you will see that the dissenting judges said that what was said by the majority at paragraph 54 was highly controversial, and they strongly disagreed with that view. and they gave the reasons for that strong disagreement. And the fourth and final point is at paragraph O18 on the next page. And you'll see that the dissenting judges took the view that the real concern that the majority had in mind was the burden that an opposite decision would be placed on the contracting state. That is simply irrelevant. Now, N was then considered by the Court of Appeal in GS India. That judgment is behind tab 5 of Authorities Volume 1. These were lead cases to consider the Strasbourg jurisprudence. And may I just take the court to one particular paragraph, and that is paragraph 66.
Well, could we have a MS page reference, please?
It's MS 699.
It's always helpful to have the MS reference to the beginning of the case before you turn to the passage you want us to read, just so that we can look at the name of the case and understand what we're
Do apologize, I'll keep that in mind. So if the case starts at page MS 675.
Thank you very much. That's lovely.
And the paragraph to which I will take my ladies and my lords to is paragraph 66, which is at MS page 699. You'll see that in that paragraph, Lord Justice Laws took the view that the effect of N is that a person may succeed only if his case is a deathbed case. And you'll see from paragraph 68, which appears on the next page, MS 700, that none of the applicants before the court met that test. So the approach adopted in N, as we have seen, was controversial. There was a strong dissenting opinion in the Strasbourg court, and it was then criticized by several judges at Strasbourg, and it was expected that one day the Strasbourg court would review the jurisprudence. May I take you to one further authority before taking the court to Paposh Valley, and that is the judgment in the case of Mwangi. It is behind tab 17 of the authorities volume, page MS 1121.
1121.
And if I may respectfully take the court to paragraph OI4, which is at page MS 1152. You'll see that this is an opinion by 6 judges. And if you look at that paragraph, OI4, you'll see that it was noted that the applicant's complaint was based on Article 3, and there is a reference then to the judgment in N. You'll see that the court picked a particular sentence from the judgment in N, and this is the sentence that I highlighted when I was showing that authority to the court, that the fact that there would be significant reduction in itself wasn't sufficient. Paragraph OI6, the court noted that that was an extreme threshold, and that was not consistent with the letter and spirit of Article 3. And the court then expressed a hope that one day the Strasbourg court may review that approach. Same sort of observations were made in several other cases. Rather than taking you to those cases, may I simply provide some references, and I'll then take you to Paposh Valley. First, MT. This is behind tab 16 of the bundle, MS page 1104, paragraphs OI1 to OI5. Second, the case of Tata. It's behind tab 22 of Authorities Volume 2, MS page 1402, paragraphs OI1 to OI5.
Did you say 1402?
Yes. Third, AE Algeria. You have that behind tab 3 of Authorities Volume 1, MS page 639. It's paragraph 6. Fourth, KK Congo, tab 7 of Authorities Volume 1, MS page 790, paragraph 8. And finally, GS and EO, you have that behind tab 4 of Authorities Volume 1, MS page 654, and the relevant paragraph is paragraph 87. So Mwanje, to which I've taken you to, and these authorities, in my submission, provide the context in which one has to look at Paposh Valley. It was considered that the time was ripe for a reconsideration of the principles in D and N, and what was envisaged in Mwanje and in these cases happened in Paposh Valley. If I may now turn to Paposh Valley, it's behind tab 19 of the Authorities Volume. Authorities Volume 2, MS page 1182. The case concerned a Georgian national facing removal from Belgium. It was not a death battery case. The applicant was not at risk of imminent death and was able to travel. He died in June 2016, but the family continued to pursue the proceedings. May I respectfully take the court to paragraph 130 of the judgment. This paragraph appears at MS page 1211. So paragraphs 130 to 132 provide the reasons as to why the court decided to entertain the matter despite the death of the applicant. The court took the view that the issue at stake was an important issue, and the court's task was not merely to decide cases on facts, but also to clarify, safeguard, and develop the rules of the convention. Paragraph 132, the court made a comment that the impact of that case goes beyond the particular situation of the applicant, unlike other similar cases, and for that reason, the judgment was given. If you then look at the next page, page MS 1212, you'll see a heading, the chamber judgment. And you'll see that at paragraph 136, it was noted what was said in N. In particular, it was noted that reduction in life expectancy in itself would not constitute a breach of Article 3. So the court recognized what was said in N. The court also recognized that in that case, the applicant was stable, fit to travel, and there was no imminent danger. Paragraph 137, medication was available, existed, the court said, in Georgia. But it was acknowledged that the accessibility was not guaranteed. Now you'll then see a heading, the parties' observations before the Grand Chamber. In my submission, it is relevant to look at the submissions to understand what the court said in the analysis. If you look at paragraph 142, which appears on the next page, MS 1213, you'll see that the applicant made a submission that the burden of proving the existence of real and practical access to healthcare in Georgia lay with the Belgian authorities because they who had greater investigative resources. Paragraph 144, first sentence, it was observed that it could not be simply presumed that the applicant would be treated in accordance with the requirements of the convention. If you look at paragraph 154, which appears on the next page, you'll see that it was submitted that it was for the authorities to make inquiries to satisfy themselves in advance that Georgian authorities could actually guarantee in practical terms that the applicant would receive health care. I emphasize on the word guarantee, which is then repeated at the end of that paragraph. Access to medical care must not be theoretical, but must be real and guaranteed.
So there are two different sorts of prospects, aren't there? The prospects of availability of medication and the prospects of his actually getting it.
Absolutely, absolutely, yes.
But these are all the applicant's submissions.
Yes, yes, and you'll see that the submissions were endorsed expressly in the analysis. Paragraph 149. Now you'll see that the applicant asked the court to depart from N to define a realistic threshold and the applicant relied on recent developments in the case law. And you'll see a reference back to what was said at paragraphs 101 onwards. So the Belgian authorities, Belgian courts had distanced themselves from the finding in N and now afforded more extensive protection than provided for under Article 3. The government's submissions start from paragraph 150. And if you look at paragraph 155, which appears at MS page 1215, you'll see that the government submitted that the burden of proof was on the applicant. Paragraph 156, 1, 2, 3, 4, fourth line, the government submitted that the applicant had not provided any detailed information on the subject, namely his resources in the context of accessibility to the treatment. And when I will address, my ladies and my lords, on the facts of this case, I'll seek to demonstrate that this is what the Secretary of State is seeking to argue in this case. The analysis start from paragraph 172, which is at MS page 1219. 174 makes a point as to when a treatment would attain a minimum level so to engage Article 3. And you will see that it was said that that would depend on all the circumstances, such as duration of the treatment, its physical and mental effects, and in some cases, sex, age, and state of health of the victim. So if a person is ill, that in itself is not sufficient. D was considered at paragraph 177. You'll see that the court recognized the fact that that case was considered as exceptional because the applicant in that case was suffering from an illness and was in the terminal stage. The court then considered the case of N at paragraph 178. If one looks at the 8th line at paragraph 178, so the court recognized that it was said in N that reduction of life expectancy in itself would not give rise to a breach of Article 3. And then, just middle of that paragraph, there are references to the applicant in N being fit to travel and the ability to access medical treatment, sport, and care in Uganda, including the help from relatives. If you look at the last sentence of paragraph 78, you'll see that it was observed that an examination of the case law subsequent to N has not revealed any such examples. The test was so high and, in my submission, unrealistic. Paragraph 179, the court notes that following N, numerous applications were declared inadmissible and manifestly ill-founded. So the court, in my submission, was plainly not satisfied with the position as it was then. Paragraph 180 is a reference to the judgment in Aswad. That was the only case where the court held that there would be a breach of Article 3 by the applicant's extradition. And that was in particular because of the effect on the applicant's mental and physical health. Paragraph 181 is a clear expression of dissatisfaction as to the principles identified above. The court observed that the threshold set in N has deprived aliens of the benefit of that provision, namely Article 3. And the court noted in the final sentence of paragraph 181 that following N, no guidance had been provided as to what constitutes very exceptional cases. Paragraph 182, the court makes what in my respective submission is an important point, that the convention is to be interpreted and applied in a manner that renders its rights practical and effective, not theoretical and illusionary. the way in which N was applied rendered, in my respectful submission, Article 3 as not being practical or effective. Final sentence of paragraph 182 is important because in that paragraph, the court said that it was proposing to clarify the correct approach. So one, in my submission, must read paragraph 183 with that in mind, that the court was seeking to clarify the principles.
So you find that convincing, do you, Mr. Malik, that this is no more than a clarification
Yes.
of the jurisprudence?
Yes, so the submission is that if the court was intending to clarify the principle, then it would be extraordinary that it wasn't able to clarify the principles because of what is said by the Secretary of State. So when the court is saying that its intention is to provide clarification, then the court is to be taken to have meant what it said at paragraph 183. So paragraph 183 is the paragraph where the court clarified as to what is meant by other very exceptional cases.
Well, they're basically saying that N left open the possibility of other cases than the deathbed cases, and now we're going to tell you what those other cases are.
Yes,
That's basically what you say they're saying.
absolutely. And what they said in my respectful submission is crystal clear. If you look at the appellant's written case, this is in the core volume, starts with MS page 39. And if I may respectfully ask the court to look at paragraph 21 of the written case, this is MS page 45. This is where I have set out, I respectfully set out a formulation that I would ask respectfully the court to endorse. In my submission, it is just not possible to read this particular paragraph in a different way. And you have my submission as to the text of that paragraph at paragraph 25 of my printed case. This is MS page 46. That what the Secretary of State is seeking to do is to read the word to as in. So the formulation that I have respectfully put forward is consistent with the natural reading of the paragraph. When the court said that this paragraph was intended to clarify things, in my submission, placing a gloss on the language is simply unjustified. If you then look at the next page in Paposhvili, this is MS page 1222. Paragraph 185, you'll see that in that paragraph, it was noted that the obligation under Article 3, the procedural obligation, would be met by taking the appropriate procedures for examination of a claim. That was then explained at paragraph 186. This in my submission is an important passage. It says, in the context of these procedures, it is for the applicant to adduce evidence capable of demonstrating ... This, in my respectful submission, is a low burden. All an applicant has to show is to produce evidence that is capable of meeting the test. A degree of speculation is inherent, and a person is not required to provide clear proof. This is the final sentence of paragraph 186. If the applicant provides evidence capable of demonstrating that the test is met, then paragraph 187 says that it is for the authorities to dispel any doubts raised by it. A point is then made at the middle of paragraph 187 that the risk alleged must be subjected to close scrutiny.
Can I just speak back to 187?
Yes.
Capable of demonstrating. Does that mean no sufficient? A prima facie case?
Yes.
Case which, if not answered, would be sufficient.
Yes. This is what the upper tribunal's presidential panel has recently said in a case to which I will take you to after Papushvili. Paragraph 187, if such evidence is adduced, it is for the state to dispel any doubts. The risk assessed must be subjected to close scrutiny. Now, one has then to look at the individual circumstances in the light of the general situation. And one then has to take into account reports of World Health Organization or other reputable non-governmental organization. Paragraph 188, the impact of the removal has to include an assessment of what would happen in the receiving state. Paragraph 189 is the paragraph which provides that if the applicant adduces evidence capable of demonstrating that the test is met, and the Secretary of State, despite providing reports, is unable to dispel doubts raised by it, then sufficient. Then the state must verify on a case-to-case basis that the care generally available is sufficient and appropriate in practice. The fact that care is available is not enough. The burden, in my respectful submission, is on the state to verify, confirm that the care is sufficient and appropriate and practical. Paragraph 190 is also an important paragraph in the context of this particular case, because that paragraph sets out the matters that a decision maker must consider. The authorities must also consider are the words used by the court. Whether an applicant has access to care, the costs of the medication and treatment, the existence of a social and family network, and distance to be traveled in order to have access to the required care. None of that was considered in my submission in this case, and I will address that by reference to the facts in due course. So my submission is that a failure by the decision maker to have regard to these factors would amount to an error of law. Paragraph 191, this is the last paragraph perhaps second last paragraph that I'll show the court. This concerns a case where, despite all that, there are still serious doubts as to what would happen. In that case, the state must, again, must is the word used by the court, obtain individual and sufficient assurances from the receiving state that appropriate treatment will be available, and not only available, but will also be accessible. The court found that there was a breach of Article 3, and if I may ask the court to look at paragraph 205 of the judgment. This is at MS page 1225. Now you'll see that there was an absence in that case of assessment by domestic authorities of the risk in the light of the information about the applicant's health and existence of appropriate treatment in Georgia. The information that was available was insufficient for them to conclude that the applicant, if returned to Georgia, would not have run a real and concrete risk. So what the court is saying is that the state has to satisfy itself that there is sufficient information to conclude that a person would not be at risk.
Mr. Malik, was there an important factual finding that we collect from the last sentence of 195 on 1224? If the treatment being administered to the applicant in Belgium that had to be discontinued, his life expectancy, based on the average, would have been less than 6 months?
Yes, that is correct. Yes.
Yes, thank you.
But that the submission is that that wasn't the reason why the court found that there was a breach. I mean, of course, the court was seeking to depart from what was said in N, and I've taken, ladies and lords, to paragraph 205, which sets out a summary of the reasons as to why the court found the breach. So that is Paposh Valley. This was considered recently by the European Court of Human Rights in the case of Severan. You have that behind tab 20 of Authorities Volume 2, MS page 1239. Sorry, 1293.
Yeah.
Apologize.
Did you look to see how many cases had been heard in Strasbourg since this? Since Papashvili, see whether or not?
I was only able to find Severan, but my learned friend, Mr. Benner, has referred to a couple of other cases in his printed case. That really is all that we were able to find.
Thank you.
Now, if I may take the court to page MS 1310. Just above paragraph 43, my ladies and lords will see a heading, General Principles. And if you look at paragraph 45, this is MS page 1311, you'll see that the court referred to Paposhvili, paragraph 183, and identified the test set out in that particular paragraph. With no gloss or qualification. Paragraph 46, the point was made that the returning state must verify on a case-to-case basis whether care is generally available, and not only it's available, but it is accessible, it is sufficient and appropriate in practice.
And this was a schizophrenic who had to have supervision.
Yes, the facts are completely different, but you'll see that the court applied what was said in Papuashvili without placing any gloss on the language that is used. Paragraph 47, you'll see that a point was made that one has to consider access to the care and the costs of the medication and treatment, existence of social and family network, and the distance to be traveled in order to access the required care. The analysis of the facts is at page MS 1315. What is said at 62 is important. It's important on the facts of this particular case, that the existence of social and family network is one of the important elements to taken into account. There's again a reference to the need to consider access to the medical treatment. And you'll see, of course, on different facts that it was observed that this is the fourth line at paragraph 62, that the applicant had no family or other social network in Turkey. Middle of next paragraph, paragraph 63, that returning him to Turkey where he has no family or other social network will cause him additional hardship and would lead to a breach of Article 3. Then look at paragraph 65. That paragraph, the court is saying that it was unclear that the applicant had a real possibility of receiving the relevant treatment in Turkey. And that led to the finding that there was a breach. If it is unclear that the applicant would be able to access medical treatment, then it is for the state to dispel the doubts. If you look at paragraph 66, the court said that that uncertainty gave rise to serious doubts. And it was for the state to dispel those doubts and to obtain sufficient assurance from the receiving state that appropriate treatment will be available and accessible. In paragraph 67, the court found that without that, the applicant's removal would violate Article 3. There was a dissenting opinion by 3 judges, and that opinion starts at page MS page 1321.
So we're basically talking about a 4-3 decision.
Yes. But even if one looks at the dissenting opinion, even those judges do not question the correctness or clarity of paragraph 183 of Papuashvili. If you look at paragraph 3 of the dissenting opinion, you'll see that the judges said, this is the second sentence of paragraph 3, that there was strict case law prior to the judgment in Papuashvili. Paragraph 4, the dissenting judges acknowledged that what was said in N was subjected to expressions of dissatisfaction and disagreement. So they too acknowledged that the position in N was unsatisfactory. Paragraph 7, MS, page 1322. Even the dissenting judges acknowledged that Paposhvili adopted and worded a new criterion to be applied in such cases. Paragraph 8, they say that the criterion is carefully worded. This is paragraph 183 of Paposhvili. This reinforces the submission that I was seeking to make, that where the court was intending to clarify the principles and was expressing itself carefully, it wouldn't be appropriate to place a gloss or to depart from the clear language used. Now, the disagreement by the dissenting judges was not on the principle or the law. If you look at paragraph 9, you'll see that the dissenting judges took the view that the principles were not correctly applied on the facts of that case. Paragraph 11, the dissenting judges again said that what was said in Paposhvili was a new criterion, and without placing any gloss, repeated what is said at paragraph 183, which of course includes the words to a significant reduction in life expectancy. Paragraph 14, which appears at 1323, again, no disagreement with the principle or the clarity or validity of what was said at 183. The dissenting judges said that the court, that the majority failed to make the assessment on the facts.
Is that a fair criticism? For my part, I couldn't see in the majority judgment any exposition of in which aspect of paragraph 183 would be satisfied. I mean, whether it would be a serious, rapid, and irreversible decline in the state of health resulting in intense suffering,
Yes.
or on your analysis, the alternative of a significant reduction in life expectancy. Is that the complaint that the dissenters are making?
Well, that appears to be the case from paragraph 14.
Yes.
I think what the majority was saying, the submission is that what the majority was saying was that the applicant had produced enough to put forward a case that was capable of success, and it was for the state to dispel the doubts and uncertainty, and the failure to obtain relevant assurances in that context led to a breach of Article 3. But for the purposes of my argument, I say that even the minority did not question the validity or clarity of what was said in Paposhvili. In principle, the disagreement was on the facts. So Severin, in my respectful submission, supports the appellant's position. There's one final authority to which I will take you to before engaging with the reasons given by the Court of Appeal. And that is the very recent decision of the upper tribunal's presidential panel in the case of AXB. You have that decision in Authorities Volume 3, MS, page 1421. Now you have the benefit of submissions from the intervener as to this decision in the intervener's case. And I respectfully adopt what is said. Just two particular paragraphs that I wish to show the court. First, paragraph 114. This is at page MS 1454.
I'm sorry, which document are we in?
This is tab 23, Authorities Volume 3, the decision of the upper tribunal in the case of AXB.
But you gave a page number of 1421.
That is right, yes.
The electronic bundle only goes up to 1416, no doubt because this is a very recent case.
Yes.
So where do we find it?
Do you have the
supplementary bundle of electronics.
do you have the hard copy of volume 3?
Well, excuse me, I want to sort out the
There's a
electronic.
Yes.
supplementary electronic bundle which somebody's...
Oh, I found it, yes.
Yes.
So I think it was labelled the Air Centres Authorities. Yes, intervenor supplementary authorities, yes.
Yes.
Okay, so it's in a separate bundle, so it
Yes.
won't be, your carrying on numbers won't work electronically. Never mind, it's in page 5, isn't it?
Yes.
Yeah. No, it's in page 5.
And I wonder if you have MS page numbers in that bundle, Milady, that
Well,
you
we do, but they're not following on from the main bundle.
Ah.
It's all right, there's always a page numbering problem in every single case. Worry not.
It is...
So the
It will be
paragraph.
sorted out.
Yes,
It's
sir.
on page 5 of the supplementary authorities bundle.
So the paragraph in the decision that I wish to show the court is paragraph 114.
114.
You'll see that the presidential panel accepted that the effect of the guidance in Papashvili is that accessibility of care and facilities must be considered. The presidential panel made no comment as to the proper interpretation of paragraph 183 of Papashvili on the basis that this court will deal with that in this case. But they said what they said at 144.
144.
Sorry, 114, I do apologize.
Yes, well, that's on page 38.
Yes. So there is a requirement to consider accessibility of care and facilities.
Does no more than require the assessing authorities to consider. So you say that's not a strong enough verb.
Yes, but for the purposes of my case, I'm content to simply say that there is an obligation to consider whether the facilities that are available are accessible as well. So failure to consider accessibility.
But it isn't just consider, is it? It's to assure themselves that...
Yes, absolutely. Yes. I mean, I made reference to requiring considerations because when I will show you the decisions made in this case, I'll seek to demonstrate that no consideration at all was given to accessibility. But that is that, and if I may also ask the court to look at paragraph 115 as well. Now, this is where the presidential panel said that the approach is a two-stage approach, and the panel highlighted the words capable of, and if that evidence is produced, then the state will need to do something to it to counter that evidence. An applicant is not required to provide clear proof. And this is the middle of paragraph 15, first sentence on the page on which paragraph 116 appears, that the returning state will need to do something with that evidence if it is to succeed in removing the person concerned compatibly with the obligations under the ECHR. Ladies and lords, if you look at the intervener's written case, this is in the same bundle. paragraphs 18 to 21, the intervener has addressed the procedural obligations and addressed this decision in particular. The intervener agrees with this decision, save as to one exception that is set out at paragraph 20. And I respectfully adopt what the intervener has said in that paragraph. Paragraph 21 says that Papuash Valley requires a three-stage assessment. And I respectfully adopt that too. The first stage requires evidence that is capable of demonstrating that the test is met. The second stage is that one must apply close scrutiny and dispel any doubts by reference to objective evidence and the individual circumstances. And the third stage is to obtain sufficient assurances. If I may now take the court to the judgment of the Court of Appeal in this case and make brief submissions as to the reasons it has given. That judgment is in co-volume, appendix tab, MS page 103. The judgment actually starts from page MS 105. If I may take the court to paragraph 38 of the judgment, this is MS page 1283. Sorry, page MS 123, I apologize. 123.
I thought so.
Yes.
Thank you.
Now you'll see that the first sentence of that paragraph says that the Strasbourg case law has now moved from the deathbed cases. That, with respect, is clearly correct. And I respectfully invite the court to accept that. But you'll see that the court then adopted a reading of paragraph 183 that is not, in my submission, justified in the light of what is said. So you'll see that the court referred to paragraph 183, quoted what is said, and then said, this is middle of paragraph 38, this means cases where the applicant faces a real risk of rapidly experiencing intense suffering, i.e. to Article 3 standard in receiving state, because their illness and non-availability there of treatment, which is available to them in the removing state, or face a real risk of death within a short time in the receiving state for the same reason. Well, if this is what the court in Papuash Valley wanted to say, it would have said so. But this is not what the court said in Papuash Valley. You'll then have further explanation from the court as to what is meant by that in the next paragraphs. And you'll see that the court read paragraph 183 by placing a gloss on the language and inserting words that are simply not there.
Which words do you say have been inserted which aren't there?
Well, the formulation is simply is not consistent with the words used, and in particular, what is being said is
It's more a syntactical issue, isn't it?
it is, but it is important.
I would find it really helpful, because it's difficult to grasp this, if you were to take the words used in 183 and
Yes.
demonstrate to us the elements which have been changed in the Court of Appeal's judgment.
Yes. So if you look at the concluding part of 38, and perhaps compare that with the actual text which helpfully appears in the same paragraph.
Can I put it to you this way? Is the Court of Appeal saying that the serious, rapid, and irreversible decline in health must qualify the significant, or the they're using the
Yes.
they're qualifying both limbs.
That's it, absolutely. So they are reading as if the word to means in, and if it assists the court at all, the intervener in their written case, paragraphs 6 to 8, has made, with respect, helpful submissions as to what was said in Paposh Valley and how that was read by the court. Paragraphs 6 to 8. So they said, in short, that significant reduction in life expectancy must be a consequence of serious, rapid, and irreversible deterioration in their health, and leading to death in a short period of time. My submission is that that is not justified on the clear language that is used. A reduction in life expectancy is a freestanding limb.
So in 183, these are the two elements.
Yes.
It's a risk of exposure to serious, rapid, and irreversible decline in his state of health, resulting in intense suffering.
Yes.
Element 1. Or exposure to significant reduction in life expectancy. That's what you get out of 183, isn't it?
Yes.
Right. And the Court of Appeal said, real risk of rapidly experiencing intense suffering or real risk of death within a short time in the receiving state. I think that's what they said in 38.
Yes, but there is more. Perhaps if I may ask the court, you have of course looked at paragraph 6 to 8 of the intervener's case. May I ask the court to look at paragraph 25 of my written case? That this is at page MS 46.
Yes.
This is how I say the court actually read the test.
Where do you get the words serious and rapid from? In that form that you've put in inverted commas there. I'm just not sure I've found the right bit of the Court of Appeal's judgment on which you're relying. Is it elsewhere than paragraph 38?
It's in 38.
No, it is.
After the reference to paragraph 183,
It's there in
This
concept.
means cases where the applicant faces a real risk of rapidly experiencing intense suffering in the receiving state because of their illness and the non-availability there of treatment, blah, 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 or faces a real risk of death within a short time for the same reason. Now, that's not actually what 183 says at all.
Because
Yes.
of the placement of the two words "to."
That's the
Yeah.
short submission, absolutely.
That's right.
So that is the case.
183 says
Yes.
either the serious, rapid and irreversibly decline in health resulting in intense suffering, or a significant reduction in life expectancy.
I'm very grateful. That really is the point.
It all depends on to and in.
That's it. That's the point. And the court below with respect is reading to as if it is in, but it is to. The Secretary of State does not even pretend that her reading is consistent with the language used in 183. She does not say that in her case. She says that the court should place a gloss on the language used because that would be justified for policy reasons. But in my respectful submission, if the language used by the court is clear, then the court should simply follow that instead of placing a gloss on it. In principle, at least at a theoretical level, the Secretary of State may legitimately say to this court that because of policy reasons, this court should not follow Papuashvili. But what she cannot do, in my submission, is to say that this court should say that Papuashvili said something that it did not say in paragraph 183.
But my lord has a point, doesn't he, about rapidity, because there's a difference between rapidity in decline in health and rapidity in a experience of suffering.
That's it.
So there are two different types of rapidity.
That's the point. So the language used is careful, as we have seen. The courts have repeatedly said. And this court, as it was noted by Lord Hope in the case of N, should take Papuashvili as it finds it, as opposed to what it may consider is the appropriate result.
Very helpfully, in paragraph 21 of your case, you have set out what in your submission, as a matter of English, this says.
This is what I respectfully invite the court to endorse. Now, if I may ask respectfully that my ladies and lords, compare what I have said at paragraph 21 with what the respondent says in her written case, and that is at page MS 69, paragraph 33. So these are the two alternative formulations. My proposed formulation is entirely consistent with the language used by the Strasbourg court. The Secretary of State is inviting this court to insert words in paragraph 183 that are simply not there.
In the case of death in a short period, they're contending there must also be a serious, rapid and irreversible deterioration in the
My
illness.
submission is that if this is what the Strasbourg court wanted to say, they would have said so.
Mr. Malik, assuming you're right on your syntactical point,
Yes.
and that your criticism of the Court of Appeal is to that extent valid, I wonder whether it's the end of this story. In 183 in Papuashvili, the Grand Chamber was seeking to explain what very exceptional cases would mean.
Yes.
If you're right in saying that a significant reduction in life expectancy is a discrete ground for an Article 3 violation, we've still got to work out what significant means. And significant is a difficult adjective, very context dependent. And so I put to you that possibly something not too far from what the Court of Appeal said, something not too far from what the Secretary of State will be saying, may be collected from giving the word significant a context-dependent meaning, and in particular, bearing in mind that this is the alternative to, quote, a serious, rapid, and irreversible decline in health resulting in intense suffering. And so when, in a case where one came to wrestle with what a significant reduction in life expectancy meant, it may be that one would invest the word significant with a meaning not all that far from substantial. What do you say about that?
Well, I have no difficulty with that. Of course, a mere reduction in life expectancy is not enough. A mere illness is not enough. The applicant must be seriously ill, and reduction must be significant. And I have no difficulty in accepting that that requires an assessment. But that, of course, alone, again, is not sufficient. The reduction, the significant reduction in life expectancy of a seriously ill person, if that person is to succeed, should also be because of the absence of the medical treatment in the receiving state or the lack of access to that treatment. I have no difficulty in accepting that. But in my yes, but
Don't you have a two-stage process? You say, is the health threshold, whatever it may be, met?
yes.
In other words, you're seriously ill, etc., etc. And if that health threshold is met, you then have to ask, but nevertheless, could it be catered for in the receiving state?
Yes.
Or would it be? I'm not stating it accurately enough, but I'm just trying to encapsulate.
Yes, so
there's a health threshold,
yes.
and then there's a treatment threshold.
Yes. Yes. So the submission is that there's actually a three-stage test that I've sought to identify at paragraph 21 of my case. So first, there must be an assessment of the illness, whether it is serious enough to bring a person within the ambit of Article 8. If the decision maker accepts that there is serious illness, the decision maker would then proceed to the second stage and consider whether there will be serious, rapid, or irreversible decline resulting in intense suffering or a significant reduction in life expectancy. The decision maker will consider what is significant in all the circumstances. If that stage is met, the assessment should then be as to whether the exposure to that is because of absence of appropriate treatment or lack of access to such treatment. This, in my submission, is principled, consistent with what the court said in Paposhvili, and respects the fact that Article 3 represents a high threshold. Now, if you then look at paragraph 39 of the Court of Appeal's judgment, this is MS page 124. Now, you'll see that in that paragraph, it was said that Paposhvili made a very modest extension to protection claims. That, with respect, is not correct. What happened in Paposhvili was far more than a very modest extension. The court then gave 5 particular reasons that the court said would justify placing a gloss on the language used in paragraph 183. The first point, this is Roman 1, is that Article 3 is an unqualified right with a high threshold. And the same point is made at Roman 5. That, of course, is correct, but my proposed formulation respects that high threshold. As I submitted, not every person who is ill would succeed. That person must be seriously ill. Not every person with reduction in life expectancy would succeed. The reduction must be significant, and not every person with significant reduction in life expectancy would succeed. That reduction must be because of the absence of the required medical treatment or access to that treatment. The second point that is made at Roman 2 is that Paposhvili approved what was said in N. I mean, of course, Paposhvili did not overrule N, but that, in my submission, does not mean that it regarded that case as correctly decided in all respects.
The Court of Appeal is there saying that the Grand Chamber specifically noted at para 178 of N
Yes.
that N was a case in which there had been no violation of Article 3. Well, Mr. Malik, they specifically noted at 178 that N was a case in which it had been held that there had been no violation of Article 3. But is it as clear that in Paposhvili the Grand Chamber was accepting for itself that there had been no violation?
No, not at all, and that is the submission that I've made at paragraph 28 of my printed case.
Oh, very well.
So paragraph 28 of my printed case is at MS page 47. So the Strasbourg Court clearly did not say that it agreed with all aspects of N. It did not say what decision it would have taken on the facts as they were in N. The Strasbourg Court wasn't saying that there was no violation on the facts in N. The next point that is made at Roman 3 concerns the use of the word very exceptional circumstances. And I've dealt with that point at paragraph 29 of my written case. The Strasbourg Court, the entire purpose of Paposhvili was to provide practical guidance as to what would fall within other very exceptional cases. The fourth point is that in Paposhvili, the court merely sought to clarify the approach in N. That point in my submission works in the appellant's favor. If the court was seeking to clarify things, then one should simply accept what the court said so clearly at paragraph 183.
But what they were clarifying was what fell within other very exceptional circumstances, i.e. other than the deathbed cases.
Yes.
That's what they were clarifying.
Yes, and they noted that no case after N had succeeded at Strasbourg level. And in N, it was noted that no case had succeeded at Strasbourg level after D. So the test what was said in N and D in my submission was not an effective protection. Now and then paragraph 40 of the Court of Appeals judgment, this is MS page 124. A point is made that, well, if one reads paragraph 183 out of context, it may mean different. In my submission, the context of paragraph 183 is set out in Paposhvili itself. there is a particular point that is made right at the end of paragraph 40 by the Court of Appeal. This is MS page 125. That it makes no sense to say, in the context of analysis under Article 3, that a serious and rapid decline in health is not a requirement where death rather than intense suffering is the expected harm. There in itself is a gravity inbuilt within the notion of death and reduction in life expectancy. Ladies and lords, I do not propose to spend much time on whether the court should depart from N. It is common ground that the court should depart from N as read in GS India, and I'm content to simply respectfully adopt the 4 points that the intervener has made at paragraphs 23 to 32 of the intervener's case as to why departure from N is justified. The court should, in my submission, keep pace with Strasbourg case law. What is said in Papush Valley is principled. It gives effect to Article 3 in an effective and practical manner. It is not inconsistent with any fundamental, substantive, or procedural principle of the domestic law. The reasoning does not overlook or misunderstand a point of principle, and this court should therefore embrace the test as formulated in in Papush Valley, as opposed to retaining the test in N that provided no more than a theoretical protection. So these are my submissions on the principle. If I may now turn to the facts of this case, and may I address the court by reference to the decisions made below. If I may first take, my ladies and my lords, to the Secretary of State's decision that triggered the appeal proceedings. That decision is in core volume, in appendix tab, MS page 175. So this is the decision of 6th of June 2013. You have the background of the case under the heading background, which sets out the basic background facts. Now, of course, the striking feature is that the applicant, the appellant came to this country as a child and has lived here for 19 years. If you then go to MS page 177, you'll see the submissions made by the applicant. And if I may ask the court to, to look at the 5th bullet point. So the appellant told the Secretary of State that his father, stepmother, and siblings were settled in the United Kingdom. He was in a subsisting relationship with a British citizen and had a British citizen child. The last bullet point on that page summarizes the submission that the applicant had, the ties the applicant had with his birthplace have weakened considerably, and his relationship in the UK is strong. Now, if you then go to page MS 185, you'll see a heading medical condition. And under that heading, the Secretary of State considered the medical condition of the appellant. If you look at the first paragraph, last line under that heading, the Secretary of State acknowledged that the appellant was taking the particular drug. The Secretary then refers to objective evidence. And if you look at fourth paragraph under the heading medical condition, which starts with the South Africa HIV and AIDS information, ... If you look at the last sentence, you'll see that the objective evidence that the Secretary of State had showed that unless subsidized by a charity or a mission hospital, all tests and HIV medication will need to be paid for at the point of delivery. If you then look at, so this concerns the costs. If you then look at the last paragraph on that page, now you'll see that a point is made about those who live at places from where they'd have to travel, and that results in further costs and makes it difficult to attend any appointments. And there is then a quotation that 500,000 people will now qualify for treatment at a cost of $7 per person per month. Of course, if that has to be considered in the context of someone living in Zimbabwe. If you then look at the next page, page 84, you'll see that it was noted that certain drugs were available. The drug that the appellant was taking wasn't listed in the objective evidence. And this is page 186, 1, 2, 3, 4, fifth paragraph. The Secretary of State said that, well, in the light of the above, it is considered that treatment for HIV is available. No proper grappling with the accessibility of that treatment. No consideration to the existence of social or the non-existence of social or family network, how the appellant is going to afford the treatment, how he is going to access it, where he is going to live, whether he live in a rural area or in an urban area, how he is going to travel. No consideration of that, no consideration of the factors listed in Paposhvili at paragraph 190. And then just above the heading facilitated return scheme, the Secretary of State says that, well, your case is not exceptional for the purposes of Article 3. So that was the decision taken by the Secretary of State. There is then the decision of the first-tier tribunal, and that decision starts from page MS 143. You'll see that that decision was promulgated on 3rd of November 2014, well before Paposhvili was decided. If you go to page MS 144, you'll see a heading burden and standard of proof. The judge under that heading says, this is the second sentence, the burden is on the appellant to establish that he should nevertheless not be deported. The standard of proof required is a balance of probabilities. Now we know for sure that that is not the standard. Balance of probabilities is not the standard that applies to Article 3 cases. The standard is whether there is a real risk of ill treatment contrary to Article 3. The judge in my submission makes a clear error in misdirecting himself as to the burden and standard of proof.
I hadn't understood that your client was arguing Article 3 at the first-tier tribunal stage.
That is correct, but And that is correct.
So it's a bit hard to complain that the judge misunderstood the burden of proof in relation to an article which was not in play.
Well, Lord, I would not have made that point if the judge had simply said that I'm not looking at Article 3 at all, despite the fact that the appellant, for a good reason, did not expressly advance an Article 3 claim. The judge nevertheless considered the Article 3 claim and found, for reasons given, that there was no breach of Article 3. And my submission is that in making that decision, the judge directed himself wrongly in assuming that the standard was the balance of probabilities. I'll show you the passage where the judge deals with the paragraph, with the Article 3 claim. If you look at paragraph 14 first, you'll see that that is where the judge refers that the Secretary of State says that Article 3 is not engaged. You'll then see a heading, the appellant's evidence, and the cross-examination starts from paragraph 20 onwards. The relevant paragraph as to what would happen in Zimbabwe is paragraph 28. So the appellant gave evidence which was not rejected by the judge, was accepted in my submission, that he had discussed with his wife as to what would happen if he is removed. She would not go with him. That is perfectly understandable. He had cousins in Zimbabwe who had passed away and had no extended family there, and all his family was here. He stated that he did not know what he would do if returned, as he did not have an education, and the courses he has done in prison would not help him in that country. So the appellant gave evidence as to lack of ties with Zimbabwe, there being no family or social support. Then go to the next page, page 148, you'll see a heading, evidence of the appellant's wife. This is where the wife sets out her circumstances and the circumstances of the appellant's child. But what is relevant for our purpose appears at page 150 at paragraph 51. The clear evidence was that she would not go to Zimbabwe, and she also confirmed that she wasn't aware of the appellant having anyone in Zimbabwe, and nor she was aware that his father had visited Zimbabwe. You then have a heading just above paragraph 56, evidence of, and the person is the appellant's mother-in-law. And for our purpose, the relevant evidence appears at paragraph 59. So she gave evidence that they needed to be a family, namely the appellant, his wife and child, not in a country where none of them knew anything. Again, that evidence wasn't rejected. The evidence was that the appellant knew nothing of Zimbabwe. Paragraph 66. This is the evidence of the appellant's aunt. She also testified that the appellant had not visited Zimbabwe since coming to the UK when he was a child, and she was not aware of any family members in that country. That evidence was not challenged by the Secretary of State. There was no cross-examination. Now, there is then a heading, submissions. Under that heading, you'll see the submissions that were made by the Secretary of State, and the submission for our purpose is at paragraph 72. So the only submission that the Secretary of State made in terms of Article 3 was that it was a high threshold medication was available and the reports were in the bundle, that's it. So no submission was made as to the non-existence of family and social network, how the appellant was going to access the treatment, how he was going to pay the costs, where he is going to live, how he's going to travel. Now, the assessment of the Article 3 claim appears at MS page 155. The judge simply said that high threshold wasn't met, and the judge obviously had the threshold of N in mind. So the judge, if the court takes the view that N wasn't the correct threshold, then that paragraph in my submission is wrong in law. In any event, if one looks at that paragraph, you'll see that the judge is saying that the evidence wasn't sufficient to reach the threshold, but we know from Papush Valley that all the appellant was required to do was to provide evidence that was capable of meeting the high threshold. The judge, in my respectful submission, appears to be applying the standard that he identified earlier in the decision, namely balance of probabilities. No consideration at all was given to the factors that the Strasbourg court says must be taken into account. If I may then take the court to MS page 169. So paragraph 175, the judge accepts the evidence that the appellant had previously tried a different drug, and that resulted in significant side effects and was discontinued. 176 is important. This records the evidence that says that it is doubtful as to whether the appellant would be able to obtain the required medication or blood tests to ensure that the treatment was successful. And just right at the end of that paragraph, this reflects the submission that I made at the outset, that without that treatment, there would be a risk of infections, and if not treated, would eventually lead to death. Paragraph 177 explains that by reference to further evidence, that if appropriate drug is not available, if his condition is not controlled, then there will be a risk of developing infections, cancers, and premature death. So that, in my submission, was enough to give rise to a case capable of meeting the threshold. But there is more in this case. Look at paragraph 178 to 180. It sets out the evidence as to the appellant's mental health. So paragraph 178, had stress and depression. The assessment showed that there was poor sleep pattern, poor appetite, found himself becoming easily irritable and annoyed. So he stated that he was suffering from depression since the death of his mother, and he received counseling. Paragraph 179, he had weekly one-to-one engagement. And 180 also refers to mental stability and longer sport. Then have at 182 reference to the objective evidence the judge accepts at the end of that paragraph that the drug that the appellant is taking is not available. But then at 183 says that, well, the evidence does not indicate that the appellant cannot tolerate any other drug. So there are a number of difficulties with the assessment. Of course, the first is that no consideration of, or no findings as to how the appellant is going to afford paying costs for his treatment. And you have the evidence recorded earlier in the decision. There's no consideration of how he's going to access the alternative medication. There's no analysis of the extent to which his mental health problems would affect his ability to access the adequate treatment. No analysis of the effect of lack of family and social support network. No assessment of where he is going to live, whether in an urban area or in a rural area, and how that would affect his ability to access the medical treatment. No assessment as to how significant was the side effect, and no assessment of the matters set out in Paposh Valley. So in my respectful submission, no matter how one looks at this case, the decision taken by the first-year tribunal is wrong in law. You then have the decision of the upper tribunal. It starts from page MS 133. And the paragraph that I wish to highlight is paragraph 27. This appears at MS page 138. Now, this is where the upper tribunal said that the burden of proof is on the appellant. It was for him to show that there would be a breach. Now, we know...
A breach of what?
A breach of Article 3 if he wished to. So it was for the appellant to establish his case. But there is no recognition of the shifting burden of proof as contemplated in Paposh Valley.
This is an appeal against the dismissal of an Article 8 claim, isn't it?
That is right, but within yes, that is right, yes. But what is being said was that the burden was on the appellant. That approach, in my submission, is again indefensible, wrong in law, for the reasons given in AXB, paragraphs 114 and 115, that clarified, that summarized the effect of Paposh Valley. There is then the judgment of the Court of Appeal. I've taken you to that judgment already. May I now show you the passages where the court dealt with the facts of this particular case? And that passage appears at page MS 125. This is paragraph 44. Now you'll see that the court took the view that the appellant failed the test in Paposh Valley. Of course, that is according to the formulation that the court adopted at paragraph 38, if that formulation is wrong, this paragraph would be unsustainable. Now, the first point that is made, this is 1, 2, 3, 4, line 5, he had used no medical. So this is where the court is considering the Article 3 claim now as opposed to Article 8 claim. It was common ground before the court that it was open to the appellant to raise Article 3. And I'm sure the court knows the reason why Article 3 claim wasn't advanced below, because it was doomed to fail on the binding authority. It was conceded that the claim cannot succeed. So here, Lord Justice Sale, as he then was, is saying that the appellant has adduced no medical report which says that he is likely to die soon if removed to Zimbabwe. Well, the first point that I make is that, well, he did not adduce that report, such a report, because Paposh Valley wasn't promulgated at the relevant time. The appellant did not know in 2014 what to aim for when the fact-finding hearing took place. It is then said that, well, he had used no medical evidence which shows that he is likely to die soon. With respect, the phrase likely to die soon is not consistent with what is said in Paposh Valley about the proper standard of proof. I mean, this appears to be an assessment on balance as to what is likely to happen. The test is not what is likely to happen, but whether there is evidence capable of showing that there is a real risk. There is then the words that would appear that he is likely to die soon if removed to Zimbabwe. I mean, that, again, is not the test. The Strasbourg court did not say in Paposh Valley that a person who is likely to die soon would succeed. That isn't the test. But there is evidence recorded in the first-year tribunal's decision that there was a risk of premature death if appropriate treatment is not available or accessible. No assessment of how significant the life expectancy would be. And this goes to the point that my Lord Wilson made. And I accepted in the course of my submissions that an assessment of reduction in life expectancy is needed, and whether it's significant will depend on all the circumstances. That assessment is missing, and there must be that assessment before the appellant could be removed compatibly with Article 3. Now, no consideration in my respectful submission is given to the factors identified in Paposh Valley at paragraph 190 as to how the appellant is going to access the treatment, how he's going to pay for it. No assessment or consideration as to how the lack of family and social support would affect his ability to access the treatment. No assessment at all as to how his mental health problems, accepted by the first-year tribunal, would affect his ability to access that treatment. No assessment of where he is going to live, how he is going to travel to the clinics, even if he had means to fund his treatment. And then if you look at the next page, page MS 126, right at the end of that paragraph, you'll see that the court made an observations that in Papush Valley, it was said that N was correctly decided. That surely is not what the court said. The Grand Chamber did not say that N on its facts was correctly decided. So what is considered at paragraph 44 in my submission is patently insufficient to dispel the doubts and to justify the appellant's removal.
Could you just pause a moment so that I can ask you,
Yes.
what is the Court of Appeal doing at this stage? Is it the first tribunal to make a determination
Absolutely.
of Article 3?
That is it. So what the court is doing in this passage is looking at the evidence itself and saying that, well, the test in Paposh Valley is not satisfied without there being proper factual findings on the matters that are relevant.
And you say, A, the Court of Appeal got the test wrong,
Yes.
and B, even if it didn't come to the right answers. Therefore, we should restate the test or say that they didn't apply, if they've got the right test, say it didn't get applied correctly and send the matter back to the first tier tribunal.
Yes.
Another analysis is that this case was run all the way through to the Court of Appeal on evidence which was not directed to this point at all.
Yes.
And that this is raised against you, the better course would be to say, you put in the evidence that you can muster with regard to this, because after all, some time has gone by as well, and let the Secretary of State decide whether that's accepted as a fresh claim, in which case it goes through the system anyway, or alternatively submit to a judicial review on that question.
Yes. Lady, yes, that was the final matter in my list of submissions.
Well, take it in its turn. But I've understood correctly that this is the Court of Appeal as the first court to consider the factual matters.
Yes, but I mean, of course, you have my note that was sent to the Court of Appeal. The appellant simply conceded that he cannot win at that level, and even said that the hearing was not necessary at all, and the court should simply dismiss the appeal on that basis. But the court nevertheless looked at the matters and decided the case, but without grappling with the relevant matters that I've just identified. Now, to answer the point that, Milady, that you made, may I respectfully do it in this way in next 10 minutes? May I take you to the respondent's written case where points such as the point that, Milady, you made are made, and if I may then perhaps just respond to those points in turn, including, Milady, the point that you have in mind. So if you look at the respondent's printed case, this is page, it starts from page MS 58, and the relevant paragraph is paragraph 42, 42 onwards. This is at page MS 71. Now, may I respectfully make very brief submissions on these paragraphs in turn. So the first point that is made at paragraph 21 is that, well, the appellant had the opportunity to submit necessary evidence, but it did not submit that evidence at the first year tribunal. I mean, you have my answer to that the appellant at that point did not know what to aim for. He knew at that time that it was impossible for him to meet the N threshold. Paragraph 43, the point is made that, well, the appellant did submit some evidence, but that evidence was considered in in a different context, namely to show whether there are any compelling circumstances. Well, the point is that, well, the appellant did not submit evidence that he could not tolerate other treatments. Well, I ask the court respectfully to consider, when is it that anyone ever raised that point? The Secretary of State did not raise that point in her decision. The presenting officer, it appears from the submissions recorded in the first year tribunal's decision, did not make that point. That point was made for the first time by the judge in the first year itself.
Could I just ask you a question about that?
Yes.
So far as tolerance or an ability to tolerate other ARTs is concerned,
Yes.
how is either side realistically going to be able to put in evidence about that? Isn't it something you have to try and see what happens?
Yes, that with respect is correct. And the way in which I would put the case is that if the appellant has tried a medication which failed and he's taking a particular medication, and if the state asserts that there are other medications that he can try, then it is for the state to dispel the doubts, at least name the drug that he may take, or to assess the significance of any side effects.
Well, a large number of drugs are set out in the original decision letter, I think, aren't there, of alternative ARTs which would be available in Zimbabwe, but which he might or might not have to pay for. But, I mean, how is either side supposed to direct evidence to the question of whether or not your client would be able to tolerate them?
You
just have to try them, don't you?
Yes,
Yeah.
Not sure if this point goes in my favor. That is the sole reason given by the judge for dismissing the appeal, and the submission is that wasn't enough of a reason. Paragraph 44, well, why the appellant hasn't adduced further evidence at the Court of Appeal level or at this court. Well, of course, I cannot expect this court to sit as a first-year tribunal and to make an assessment as to the facts. I could not expect the Court of Appeal to have done that. For that good reason, no further evidence has been adduced. I think the next point, paragraph 45, I think this is the point that, lady, you had in mind. Now, I'm not, I emphasize, asking the court to allow the appeal and send the matter back simply because I want to adduce further evidence. My submission is that the decisions made below are wrong in law, and that justifies the remittal. If the matter is remitted, the appellant will adduce further evidence. It is not the other way around. If the court is satisfied that the decision made by the first-year tribunal was wrong in law, then it would mean that the upper tribunal and the Court of Appeal erred in upholding that decision. And that would justify a remittal. It would be incidental that at a reconsideration, the appellant would be able to provide further evidence. There is now, on my instructions, further evidence that is available, which is understandable because the fact-finding hearing took place way back in 2014.
But that otherwise the findings would stand.
Findings would stand, absolutely. My issue, milady, is not with the findings made by the first-year tribunal. The submission is that those findings are not enough. There are no findings on the relevant matters, not seeking to reverse findings made by the first-year. My submission is that there are simply no findings on the relevant matters. There is then...
When following the dismissal of the appeal by the upper tribunal,
Yes.
the Papashvili decision was promulgated,
Yes.
could you, instead of appealing to the Court of Appeal, have made a fresh Article 3 claim?
Not in a realistic sense, because any fresh claim would have to be determined by reference to N as opposed to Papashvili. because N was inconsistent with Papuashvili and the Secretary of State, and the tribunals would have been obliged to follow N and disregard
Oh, I see
Papuashvili
what you
altogether.
mean. Yes, I see what you mean.
So there's no point making a fresh claim.
Yeah, very well.
Now, paragraph 46, and again, this is the point I think that Lady Black had in mind, that, well, there is a mechanism for a fresh claim. Well, there is always a possibility for an appellant to make a fresh claim. That does not justify dismissing the appeal. Again, I emphasize that if the court is satisfied that there is an error of law in the decision made by the first-year tribunal, that would justify a remittal. Of course, if there is no error of law, the court would dismiss the appeal. But the court should not dismiss the appeal simply on the basis that the appellant may make a fresh claim. And this, there's a further point that is made at 48, that, there may be a delay, and there is a public interest in resolving this matter as swiftly as possible. If anything, that works in my favor. On remittal, a fact-finding tribunal can hear this appeal within weeks. The Secretary of State may apply for expedition. The court will set out the legal principles. The fact-finding tribunal will make a finding and will decide the case one way or another, and that would be the end of the matter. That is far more convenient and effective, rather than starting the cycle again and expecting the appellant to make further submissions, which would then be considered by the Secretary of State, and if refused, would trigger a judicial review or another appeal. If you then look at paragraph 49, so the Secretary of State says that, well, yes, anxious scrutiny applies, but that does not mean that the appellant should get an opportunity to submit further evidence. I accept that. I do not expect or ask this court to allow my appeal simply on the basis that I want to submit further evidence. Anxious scrutiny means that every factor which might tell in favor of the appellant should properly be taken into account. The matters that I identified earlier in my submissions, namely accessibility, costs, lack of family, social support, mental health problems, where the appellant was going to live, were not considered at all. And that gives rise to an error of law that justifies the remittal. Then paragraph 51. 51.1, the first year found that the appellant had not proved that he would not be able to access suitable treatment, but the first year tribunal applied the wrong standard of proof, failed to consider all material matters in line with paragraph 190 of Papuashvili. So this point does not really meet the submissions that I make. Paragraph 51.2 is an invitation to this court by the Secretary of State to sit as a fact-finding tribunal, look at the objective evidence that is cited, and take the view that there would be no breach of Article 8. This court, with respect, cannot do that. This court cannot make findings on the matters that I identified. I mean, that would require a fact-finding hearing. So whether, for instance, the appellant can afford the costs, this court has no means to decide that point. And then finally, paragraph 51.3, the appellant produced no evidence that he would suffer side effects, and there was no need for the finding as to how side effects would be managed. Well, it was the Court of Appeal that made that point for the very first time. It wasn't made by the Secretary of State, by the first year, or by the upper tribunal. The Court of Appeal said that, well, even if the appellant is to face side effects, there is no evidence as to how serious those side effects would be, whether those side effects would bring him within Article 3. And all I was saying that if that is a valid point, then there must be a proper assessment of how serious those side effects would be, whether they would be significant or curable or tolerable. There's no assessment at all of that. So that point two in my submission does not answer the points that I have made. So in conclusion, Lords, I say that any decision that this court will make will have profound consequences, not only for the appellant, but also for his British citizen wife and British citizen child. If the court has any doubts, those doubts should be resolved in the appellant's favor at this stage, and the matter should be remitted either to the first-tier tribunal or to the upper tribunal. I have no particular preference, because both tribunals can sit as a fact-finding tribunal for there to be a proper assessment of the Article 3 claim and of the matters that I have repeatedly emphasized in the course of my submissions. So unless I can assist the court any further, these are my submissions.
Well, thank you very much indeed, Mr. Malik. Mr. Balru? You finished half an hour ahead of time.
Yes.
Well, we haven't been testing you enough, have we? Well, very well, we will adjourn now, and I think we hear from Mr. Banner next. Yes, at 2:00.